Please be seated. Veuillez vous asseoir.
Good morning again, everyone. And defense, you have 60 minutes to summarize your case.
Madame la Présidente,
Ms. Nauri, Your Honor, as was the case yesterday, the prosecution did use its time in a certain way, and there was a bit of flexibility. And I think we will be asking for much the same. I think we will finish within the 60 minutes. I'll let Mr. Jacobs finish his remarks, and then I will present the final submissions in the remaining 45 seconds. And I think we will be able to keep within the time frame. And of course, I'll now turn over to my colleague, Mr. Jacobs.
Certainly, Ms. Nauri. You can use your time in the manner you want, and we'll have the summary of your case within what Mr. Jacobs has to say now in response to the prosecution's case, and the summary of it within the 60 minutes. That's acceptable. Thank you. Mr. Jacobs, please.
Mr. Jacobs, thank you, Madam President.
Alors je reprends là où j'en étais.
Let me take up again where I was before the break. I was talking about the incidents and the fact that at times the prosecution took a rather isolated approach, whereas the defense took a holistic approach. And when you look at the incidents in their entirety, you see that the reality was quite different to what the prosecution would have you believe. Yesterday, during the hearing, the prosecution quoted a number of witnesses who said that they had been arrested because they had been perceived to be Bozizé supporters. Already, I believe we must wonder about the credibility of witnesses who are first arrested by the police and obviously do not want to appear before the International Criminal Court and admit that they are ordinary criminals. By definition, their credibility must be assessed carefully. Above all, these statements were immediately contradicted by the same witnesses themselves, who all gave an account of why they had been arrested. One had been trapped by a colleague and he hadn't paid a debt. One had been associated with the Seleka. One had machetes in his possession. They all gave reasons for their arrest. So by definition, that contradicts what was said, namely that they were arrested because they were perceived to be Bozizé supporters. Similarly, we drop a long list of similar contradictions in our closing brief. For example, there were career police officers at the OCRB and prosecutors of the Republic. And it would appear that witnesses said that it was Tolmo, for instance, who wanted them arrested, who put them in the cells, who arrested them, who released them. These were prosecution witnesses who said that, but Tolmo, to the best of my knowledge, was not a Seleka member.
Pareil, si on regarde les...
It's much the same thing if you look at the various incidents together. 10 of the incidents. 10. In 10 cases, Mr. Said was not even mentioned. 10. That's And that's a lot of incidents. This is supposed to be the heart of the case. And the prosecution would have you believe that the mode of liability was direct. But Mr. Said was not even mentioned in the majority of the incidents, so we really do wonder.
Dernier point sur les incidents, Madame la
One last point about the incidents. The prosecution took the stance yesterday that it was not serious if they had only one witness, as long as he was reliable. But that is a matter up for debate. We would put it that the witnesses, in the plural, are not reliable. We've already mentioned one witness who gave a false identity to the court, a witness who lied about the amount of time he spent at the OCRB. He said 1 month and then he said a few weeks. Incident F, number F, the witness changed his mind. That was a single witness, uncorroborated, who said that he saw 3 people who were killed, but during the hearing, he said 7 people. Then he said 24 people, 1 person. This is witness P0481. This was not corroborated. There's no material evidence, but we're supposed to believe this witness. There's a problem with a single witness who is not reliable. One convicts a person at the ICC on the basis of what a single witness has said, an unreliable witness. What can you do with testimony like this? 7 people, 3 people, and then the next day he says 22. Incident N. The prosecution themselves confronted that witness with his previous statement because it was unclear whether he was there during the arrest or not. He changed his mind. How can one believe such a witness? P1737. As for the legal characterization of the events, there are many things, many points I could make, but I'm trying to be selective here, Your Honors. The prosecution has not gone one incident at a time, one by one, to determine which legal qualification of events would be appropriate. They have not proceeded one incident at a time. If they had done that, they would be able to explain, for instance. And this example has already been mentioned, and I think it is quite symbolic. Incident N. A person was found guilty. Correction, incident L. This person was perceived to be a Bozizé supporter. Incident L. If the prosecution had conducted this exercise, they would have looked at incident K, a person who was arrested at the orders of Alain Tolmont and then a few hours later released by Benjamin Malot without even being placed in detention. How could this be included in any of the counts? He was not even detained. Mention is made of inhumane conditions, but he was never detained. So what count actually corresponds to what I'm describing here today? None. Yesterday, the prosecution claimed, and I made this point in the closing brief, that, and the prosecution was not able to make this point yesterday during their final remarks, nor in their closing brief. Now, how can it be that the number of people actually being held in detention at the OCRB, how can this number vary so much? If there was a state policy, if all the people at the OCRB were former Seleka members or common criminals, where is this policy? People said that they were targeted because they were former Seleka members or part of the presidential guard, but you saw how many people. You saw in the case record that all the FACA members came to work. One witness gave a list of all the presidential guard members under Bozizé who worked under Jitoja, for Jitoja. So where's the targeting there? They worked under Jitoja at Camp de Rue. They worked with him. Where was the target? They have drawn up a list of people, Christians, Baja ethnic members. That's a list of many, many people in the Central African Republic. The majority. So if someone has been arrested in Bangui, it's quite likely that the person was a Christian and a Baya person, but that proves nothing at all. Most of the victims or the people arrested were men. And what am I to understand? Is the prosecution saying that all the men in Bangui were presumed to be Bozizé supporters? This is ridiculous. To conclude, I would like to return to the point of Mr. Said not bearing criminal responsibility. Now, one word about the mode of liability. The prosecution spent a great deal of time yesterday speaking to this point, but never really explaining what the mode of liability was. They quoted jurisprudence. They spoke of indirect coaction. They mentioned the Onguin case. We still really don't know which mode of liability. Case law from the Onguin case. I'll move on. As for the common plan, once again, the prosecution defends their evidence, no matter how weak it is. They say, oh, it doesn't matter that the evidence is weak. It doesn't. But if you read the closing brief, they seem to be saying that the common plan can be derived from the crimes. It's something you can deduce. You can easily deduce the common plan from the commission of crimes. Not necessary to demonstrate the contribution, because it all can be deduced from the common plan, which in turn is deduced from the commission of the crimes, and so on and so forth. Sort of like a stair in a Escher painting, a stairway that leads nowhere.
Et l'accusation nous dit hier.
Yesterday, the prosecution told us that we are the ones to decide who in the common plan, about the common plan and the proof that it was Linguisada and that Tolmo, and that there were career police officers at the OCRB.
En conclusion, l'on se retrouve à la fin.
To conclude, at the end of the closing brief of the prosecution, we find ourselves asking the same questions. The prosecution has not listened to their own witnesses, and if they don't listen to their own witnesses, on what basis are they asking you, the chamber, to believe them? They would like you to believe these uncorroborated witnesses when it suits them, and disregard information when it doesn't suit them. This is not an acceptable approach to assessing evidence at the International Criminal Court. The prosecution has made up a story, a work of fiction, a fiction that does not need to be proved, a work of imagination. I will leave it at that, Your Honor.
Madame la Présidente, Madame, Messieurs.
Your Honor, Madam President,
J'ai écouté.
I have carefully listened to the hearings, and I've heard an account made up of bits and bobs, an account that twists the words of their witnesses and makes the recent history of the Central African Republic a travesty. The Central African Republic deserves better. That country deserves that its history, reality, is taken into account properly, without distortions, without simplifications, or without caricatures. The Central African Republic deserves us to pay tribute to the nation's sovereignty, so often interfered with, and the prosecution never really talked about the self-defense groups that allegedly made up the Seleka. And why? Because they would have to concede that it was impossible for those groups to organize into something larger or to form a structure. It's as if the prosecution, after reading their closing brief and the closing brief of the LRV, it's as if they wanted everyone to forget about the challenges of the north part of the country. For decades, that part of the country, the government was dissolving, breaking down. That part of the country was plagued by all kinds of crime, particularly by the crime of the Zaraguingas. It's as if the prosecution would like us to forget P0349, who told us about the North, a place where there was no drinking water, no roads, no electricity. It's as if they wanted to deny the fact that the Bozizé government ran the state as if it were a private company, and that they had driven all the FACA away. And yet the evidence is there. The self-defense groups in the north were created to make up for the vacuum that was left behind, the lack of a state. For example, if I could move on to the situation in Libreville, the coalition had no agenda. They had no ideology, no political platform that was consistent. And if we look at that finding, and when we consider the testimony and the documentary evidence, the prosecution had to concede that there was no chain of command within the coalition, no centralized chain of command. They said so in their brief. It is true. It's true. There was no centralized chain of command. And yet they did not draw any sort of conclusion or consequence from that. If the chain of command was not centralized before the 24th of March 2013, how could that coalition have magically turned into an organized structure? When you look at the case record, it's impossible to answer that question. I want to repeat this point. This is essential. We don't know, after the 24th of March, how an unstructured coalition could have magically become a structured coalition. And to set aside that failing within their case, the prosecution has decided to act differently. They have presumed a certain degree of coordination because a number of groups came to Bangui. And if we talk about these people flowing into Bangui, even though this is outside of the time frame, the situation was entirely chaotic. There was no coordination. Some people joined up with friends after all kinds of trips, going here, there, taking this road, that road, taxis. At another time, they said that they repaired a taxi. Then another witness gave us an account with a particular route that is entirely inconceivable. 2563. In actual fact, even before the period of the charges, no instructions about which route to take, nothing about coordination of a group. No FACA positions had been identified, nothing. No witness who was called was at any meeting whatsoever of Seleka leaders. None. They merely give us an account of hearsay. They understand nothing. And when it comes to the actual time when everyone was streaming into Bangui, well, basically, they show us a map depicting the hearsay and ask us to believe it.
So what's the prosecution saying? They're saying that they were coordinated because they had military ranks. But this reveals the lack of realism, and it's the fact that it's not listening to his witness. At least 13 witnesses explained that ranks were self-assigned and therefore did not reflect any hierarchy. P0338, P2563, P2105, P2240, P1563, P0964, P2161, P1737, P0234, P0119, P2926, P0035, P0037. What are they saying? And I'm just actually saying that these ranks were absolutely fantastical. And they were self-assigned, self-attributed. And there's a witness that says, and I quote, in the Salika, there were, and it's fair to say, several hundred colonels, even those who weren't there at the start when the Salika arrived in Bangui. Even traders in Bangui with limited means became colonels. It's P2105 that I quoted. Witnesses also report that upon arrival in Bangui, the FACA disbanded, and there was no fighting apart from a skirmish with South Africans at PK5. In reality, the case file shows that the instructions clearly conveyed by the representatives of the Bozize government were to lay down arms and flee the fighting. In such a context, there was no need for organizational coordination. They disbanded, they left, and they surrendered, put down their arms. And what did the new arrivals in the Bangui do? And I told you this morning, each one was going basically to find his own bounty or his loot. But in such a situation, where everyone in Bangui is actually trying to get richer and claiming themselves to be Salika. So what exactly is the prosecution referring to after the 24th of March 2013? It is impossible to know. So this morning we spoke about the Salika government created by the prosecution, and we demonstrated how it was basically a national government, and I'm not going to come back to this. What's really interesting is the instruction given by this government that functions with its ministers. Now, the witnesses, whether it's the military police, the OCRB staff, or the ministers, say that it's the government of Jotoja who gave instructions, who issued instructions, and I insist, ever since the prosecution speaks of a policy implemented by a government that it defines as Salika, what it must demonstrate is that the members from the presidential majority should have a plan and give instructions, especially to the police. And how do they give this police these instructions? By written documents, by meetings, so that this policy can be implemented. And that's what the prosecution must prove. And the instructions are there. These are these confidence-building measures. And I'm going to come back to this, but I want to talk about this government, which is multi-party, but also has a security advisory body, which, for the prosecution, is a suspicious weekly meeting forum. This is what they said. But this national advisory body is created by the Prime Minister. They just said it. And all members of the government participate in order to set out the objectives and coordinate the security policy of the defense. Now, that's absolutely normal. When there is a transition government, it's good to have an advisory body which is in charge of the security policy and defense policy. And what do the witnesses say? Who comes to these meetings? Where the questions on securing the capital, billeting, disarming people bearing arms are discussed. So you have the chief of staff. No, he's not Salika. The director general of the police, the director general of the military police, gendarmerie, the prime minister, and international representatives. Have you ever seen a state that decides to come up with a plan with a single political party in the presence of international representatives like France? We really actually far from this French government having a meeting in front of international representatives, and I can actually send you an attendance list of people who attended the meeting. Now, these instructions given during the meetings they show a will on behalf of the government to restore stability in the country through these confidence-building measures. Now, confidence-building measures are actually decided upon in front of the international community. First of all, you have instructions to encourage... I'm sorry. First of all, you have instructions to encourage civil servants to get back to work. We have several calls, official calls. We have several official calls from the President, from the Prime Minister, from the Army Chief of Staff, who basically instruct civil servants to get back to work. We also have radio broadcasts. And the call from Jetoja is again issued for the police officers through Noureddin Adam, the minister. And this basically, it's Benjamin Malo who said that, who testified to that. Now, unlike what the prosecution says, the new authorities encouraged FACA, who were seemingly targeted, and it's the government that encouraged these FACA to get back to work. And it's not to amuse the public, because it's going to bear fruit, and this is what the Prime Minister Chiang Kai says. It does bear fruit. And this has been confirmed by a security report dated 25th of July. And it says that 749 police officers went back to work. 2,600 military police officers went back to work. 4,458 FACA agents went back to work. This is tab A, tab 1 from our list of notifications. Other instructions, arresting the uncontrolled arm bearers, weapons bearers. So this instruction is implemented through the joint patrols, comprising official civil servants, members of FOMAC, and voluntaries from the 5 groups of the coalition. And here again, there are meetings at the FOMAC, where the general of FOMAC suggested to Jetodia, the president, and I'm quoting, a officer from the Selika should be appointed in order to work together with FOMAC in order to end these exactions. So again, there are meetings. There are meetings where FOMAC agents are saying that we will be collaborating with Selika generals, and this is not something that is hidden. And what's happening? The Director General of the Police, Lingi Sara, participates in implementing these confidence-building measures. A member of the military police, P2563, says that it's Jetodia who created the military police in order to avoid criminal activity and to basically get the people to lay down their arms, corroborated by the elements. But there is a report on the security situation of the 25th of July 2013 that indicates that in order to disarm uncontrolled agents, activities have been carried out by a joint team comprising of disciplined Selika elements, gendarmerie, the military police, the police, and FOMAC, the Central African Force. It's quite clear. They are working to implement the confidence-building measures. Now, with regard to the instruction to billet and disarm, we've seen the joint patrols here, and the CNS is also participating in implementing the billeting and the disarmament process. And as of 29th of March 2013, Chongai, the Prime Minister, says on RFE the initiatives deployed for billeting, and this is a government-led initiative. During a meeting with the SEMA, which the Army Chief of Staff, the Ambassador of Chad, Mr. Babacar from the UN, and General Mukoyo from the African Union, the President Jotodia gave an instruction to the Army Chief of Staff, Dole Roya, to implement a joint force for billeting. So again, it's the auspices of this is again under the auspices of the international community. Another evidence that's corroborated in a press release dated the 3rd of April 2030, the Minister of Security calls for billeting, and he says, and I'm quoting him, the uncontrolled elements bearing arms who are making the most of the situation, who are continuing to loot and vandalize and committing other exactions, should stop doing so immediately. Tab 605. So these are the instructions issued by the Ministry of Security. Stop your acts, your exactions, and we're going to disarm you. This is absolutely positive. No inference, no hypothesis. It's clearly to be drawn from the evidence. So the OCRB was basically drawing on these confidence-building measures. This is not something new for Jotodia. We've seen this morning for the government. It's an open place where the public can go, whether it's for family visits or the international representatives. And I've said this morning, witnesses have shown that this is a place that's extremely open. It's a place of temporary detaining and temporary remand. People who are suspected are held there. These people suspected who were there are basically low-level bandits. And I just wanted to add something. I'm not saying this. It's the witnesses, P2519, who says that amongst this 17 prisoners, 3 were FACA, 2 were civilians, and all the others were basically Selika. P2563 says the detainees were diverse in nature, and it was maintained at the OCRB for various reasons. And he specifies that the uncontrolled elements had actually looted the population, and these are the grounds for arrest, and this is why they're in prison. And P2239 says that most of the other prisoners were young Selika delinquents who were accused of robbery, drug trafficking, and theft. In fact, when you listen to the witnesses, their narratives illustrate that they're actually suspected of common infractions. One witness was arrested because he was transporting a suspicious suitcase of documents. This these were sensitive documents, and he was basically crossing the border between the CAR and the DRC. Another witness was suspected of having an weapon in his possession and committing a crime. One witness was suspected of stealing gold. Another witness suspected of not paying back his debt. Another witness was suspected of stealing diamonds. Another suspect was suspected with association with Silic. Another one was holding a machete, and another was actually the subject of a complaint filed against him, and the list continues. I'd like to actually refer you to our brief. And this is exactly what happens, what's coming out from the case. As it's clear that the OCRB is trying to function in spite of the fact that it is understaffed. And the witnesses who worked at the OCRB say that the OCRB is a mixed unit. P2161 says that the repression unit is a mixed unit. It's not my words. These are his words. There you had the National Police supported by the Silica, and they specify that all OCRB staff received instructions from the Minister of Security without any distinction, irrespective of where they come from. Now, what P1737 is confirming, this organization has been put in place upon the instruction of Jatoda, and this is what P1019 confirms, as I said in my opening speech. The insider witnesses, P0338, P0378 say that the officials of the judicial police have an active role, and this is confirmed by the other OCRB staff and the detainees as well. The OPG were receiving complaints. They carried out investigations, especially on the crimes. They were hearing detainees. They were working with the prosecutor. Benjamin Amalou, who was the director of the OCRB, explains that he had the keys of the cell. He organized the movement of the members of the government. He carried out investigations and also received direct instructions from the Director General of the Police. So this is the judicial police we're talking about, the synonym OPG, the judicial police. The members of the supporting mission are basically in charge of administrative work, logistic work, staff management, purchasing, procurement, and also secretarial tasks such as registration. So all support staff have actually registered the detainees, and this is their main job. With regard to the organization of the supporting support mission, it is not possible to know who was part of this mission and when, and you really cannot draw up a hierarchical chart. This is what Benjamin Malo corroborates, and the P034, who actually says it, he says that the hierarchy was changing all the time. Benjamin Malo said that some of the people were actually uncontrollable, they were consuming drugs, and they would answer to no one, and they would act by their own will, especially a certain person called Mr. Tahir, who was designated by a witness on the basis of a photo as a person who is in charge of his misfortune, and not Mr. Said. And this is why many people designated various heads at the OCRB, especially with regard to the incidents. As I was saying this morning, there's Tahir, Mazangir, Lingi Saha, a gentleman with a long beard and long hair. So when there is such a doubt on the person in charge of the OCRB, this doubt cannot be overlooked. Now the reality. At the OCRB, there were efforts to implement the peacekeeping law enforcement, but it was very difficult because of lack of directives, because of excessive criminal behavior for personal reasons. And this is what comes out from the incidents in the file. Let's take the example of the incident against P0547. The person who had P0547 is a person who was actually was under the influence of narcotics, and that is exactly what the witness said. He did not say because he was asked to do something, he was drugged, and he apologized later. And that's extremely unfortunate. But this is excessive behavior that is not for international crime, and it's definitely not about any kind of common plotting or anything. You really have to be realistic about all this when you analyze incidents that are being discussed here, and they have to be put in their context, in the Central African context. The ICC the mission of the ICC is not about interfering in the institutions of the state, of a country. The narratives of the witnesses basically tell us about how the OCB worked during the period covered by the charges and before, and including today. P1737 basically puts it the right way. This actually brings the Central African reality at the heart of the debate at the ICC. He says, the OCRB, the Central Office for the Suppression of Banditry, this department bears its name because it's a police-based organization where police officers were basically combating banditry in the country. And until this very day, when you go to the OCRB, certainly you will observe that you'll observe this after a couple of days. You will see from time to time small criminals who are arrested and who are taken to the OCRB to be beaten, corrected, so that they do not become repeat offenders. I never said that people were arrested anyway and they were brought to the OCRB to be beaten. That is not what I said. I just gave you the real explanation. Until this day, the witness says, I just gave you the real explanation. And I think it's crucial that we demonstrate that we can listen to the witnesses in this court without any a priori, and we should know when this goes beyond our jurisdiction. Now, there are cases that basically are for the national legislation, and there is no war, there is no attack, And it's basically up to the Central African Republic to take ownership of its history, but we cannot impose unrealistic standards on the country. Madam President, Your Honours, the evidence is here and it's compelling. The prosecution actually thrust upon us imaginary reality, and they did not call upon the experts who would have actually put an end to their narrative. It is up to us at the end of the trial to give the word back to the Central Africans. Their narrative comes from a reality that was existing in Bangui during troubled times prior to the fall of a regime characterized by chaos and efforts to basically restore public order. And we have to know when international justice should step in and when national justice should step in. Currently, we all have to give their destiny back to the Central African people and give Mr. Said back to his country. I said this at the opening of the trial. The Central African Republic is a country that the Africans say that the destiny was stolen away from the people of the country. Let's not take any more from them. Let's give the country back its autonomy by give back its jurisdiction and competence. And this is where the entire point of the case is. The prosecution did not actually present a case which is for international justice. It's uprooted Mr. Said from its origins, and he paid the price on account of his health. Mr. Said never yielded in spite of the obstacles, in spite of a coma that lasted several weeks, big operations, and he was far from his near and dear ones for such a long time, except in spite of the pain, in spite of the health problems, the various health problems he's still undergoing. He actually was there in this court without evading, without causing any delays. He came sometimes, and it was very difficult for him, so that justice is done, because he believes in justice and in the truth. This truth is there. It's right in front of our eyes. And it's the task of the chamber to unveil this. And all the witnesses who had the courage to talk about this, you, Your Honor, and the bench must recall that there can't be justice without truth. It's on the prosecution to provide it's on the prosecution that must provide proof, not the defense. The burden of the proof rests on the shoulders of the prosecution and not on the defense. We must focus on the facts. The facts come from reality. And this reality is right there before our eyes. Let's take note. Let's draw all the necessary conclusions and recognize Mr. Said's innocence by clearing him of all charges. That will be justice. Thank you so much, Your Honor.
Thank you very much, Ms. Nauri. Now, this brings us to the end of the closing statements in this case. And pursuant to Rule 142, Sub 1 of the Rules of Procedure and Evidence, the Chamber will now retire to deliberate on its judgment pursuant to Article 74 of the Rome Statute. The Chamber notes that in its judgment, it will decide whether to convict or acquit the accused. If, and only if, the outcome is a conviction, sentencing procedures will follow. The Chamber puts the parties and participants on notice that if there is a conviction in this case, it intends to proceed to sentencing as expeditiously as possible. So with this in mind, the Chamber trusts that the parties and participants will make proper use of the time in preparation of any outcome of the proceedings pending the trial judgment's issuance. This instruction is given without prejudice to the decision of without any prejudice of any decision the Chamber may take as to the guilt or innocence of the accused. That said, speaking on my own behalf as presiding judge of this chamber, and on behalf of my colleagues, judges, I would like to thank the prosecution, the defense, the victims' representatives for their dedication and assistance during this trial. I thank persons here present in the courtroom and those viewing online, especially those viewing from the Central African Republic. In addition, these proceedings would not have been possible without the support of the registry. I've said it many times before, but I thank the court officers and the court clerk, the interpreters and court reporters, the victims and witness unit, our abled security officers, and all staff behind the scenes who made this trial possible. Your skills and professionalism are commended. Finally, I'd like to express our thanks to the Chamber's legal and administrative staff for their invaluable assistance throughout this trial. I thank you all very much. This matter stands adjourned.
All rise. Veuillez vous lever.